Are non-compete agreements enforceable in Georgia? The answer is yes, and Georgia has specific rules that make enforcing these agreements easier than in many other states. Non-compete agreements in Georgia underwent significant changes after 2011. Before this time, these agreements were often considered void and unenforceable. Courts would typically invalidate an entire agreement if it contained any unenforceable terms. The legal landscape changed dramatically when Georgia amended its constitution and passed the Restrictive Covenants Act in May 2011. This amendment made non-compete agreements much more business-friendly and enforceable. Under the old rules, Georgia courts applied strict scrutiny to non-compete agreements, often ruling against them. The new law created a more balanced approach. Now, courts have the ability to modify or blue pencil agreements rather than throwing them out entirely. This means they can remove problematic terms while keeping the overall agreement intact. For a non-compete agreement to be enforceable in Georgia, it must contain several key elements. First, there must be consideration, something of value given to the employee in exchange for signing. For new employees, the job itself can serve as consideration. For existing employees, additional benefits or compensation may be required. Second, the agreement must be reasonable in terms of time duration. Typically, periods up to 2 years are considered reasonable in Georgia. Anything longer may face greater scrutiny from courts. Third, geographic restrictions must be reasonable and limited to areas where the employer actually conducts business. Interestingly, Georgia law now allows employers to include territories where they plan to expand in the future. Fourth, the scope of restricted activities must be clearly defined and reasonable. The new law allows employers to broadly define what constitutes competing activities. It's important to note that non-compete agreements in Georgia can only be applied to specific categories of employees. These include sales staff, vital employees or company professionals, management positions, and employees who regularly solicit business from customers. If an employee doesn't fall into one of these categories, the agreement would not be enforceable after termination. The law also addresses non-solicitation provisions. Former employees can be prevented from soliciting clients or other employees, but only if they had previous business interactions with these individuals. Preventing solicitation of clients with whom the employee had no relationship is generally not enforceable. Regarding non-disclosure provisions, the new law removed previous time limitations. Now, non-disclosure provisions can remain valid as long as the information continues to be a trade secret or needs to remain confidential for business success. If a non-compete agreement is violated, employers have several legal options. They can seek injunctions to prevent an employee from working for a competitor. They can pursue monetary damages if they've suffered financial losses due to the violation. Many employers start with cease and desist orders before moving to litigation. Some common questions about non-compete agreements in Georgia include whether you can be fired for refusing to sign one. The answer is yes. Georgia is an at-will employment state, meaning employers can terminate employees who refuse to sign. Another frequent question concerns what happens if you were laid off. If you were terminated without cause, you may have grounds to challenge enforcement. However, if you voluntarily left your employer, courts are more likely to uphold the restrictions. Georgia's approach to non-compete agreements represents a significant shift toward employer-friendly policies. While these agreements are now more enforceable, they still must protect legitimate business interests and contain reasonable restrictions on time, geography, and scope of activities. Both employers and employees should understand these requirements to ensure their rights are protected under Georgia law.